Good afternoon. Welcome to our video series. I am joined by Bruce Thiele, barrister, arbitrator on the Sunshine Coast here with 30 years experience, and Leisa Toomey from Toomey Family Law, who is also an accredited family law specialist with 30 years experience, including some time as a children's lawyer. So thank you so much for joining me.
Thanks for having us.
Thank you.
We are here to talk arbitration. So Bruce, tell me, what is arbitration?
Well, as simple as I can express it, arbitration is where the parties engage an independent person, such as a barrister or a solicitor like me, to determine their financial dispute rather than putting the matter through the family court system.
So how does it differ to mediation?
Well, the difference between mediation and arbitration is mediation, the parties themselves try to come up with the solution and they reach the agreement themselves, whereas in an arbitration, I make the decision for them, as a judge would make a decision for the parties if they were in court.
So is it as legally binding as though it was going through a court?
Absolutely, absolutely. Once an award is made by an arbitrator, the parties or a party then registers the award with the family court or in the family court, and it then becomes binding as if it was an order of the court and enforceable in the same way.
Leisa, what would be the benefits of a client going through arbitration versus going to court, and when or how would you recommend that?
Letitia, the big problem these days is how long it takes for matters to go through the court system. We're hearing horror stories up to 24 months to actually get before a judge to hear the matter. Then we're hearing delays in relation to judgments coming out. There's recently been a decision by the court where it took a judge some 7 years to make a final decision in a matter. So knowing that that's really the background to it, you would be promoting arbitration because it's a much more expedient way to get a result, so the parties aren't waiting around those long exhaustive times. Also, the benefit is that it's a much cheaper process, and indeed the client and the parties can really tailor their arbitration to how they want it to actually take place. And I think Bruce will be with me on this. Not every arbitration is the same. Not all the formulas are the same. Lawyers may want a different approach to their arbitration. So that's one of the real benefits to it.
So you're saying that a lawyer can not influence, but sort of you can take those special parameters and have that discussion with the arbitrator to say, look, these are the extenuating circumstances. Could you explain that a little bit more?
Sure. Well, actually, maybe Bruce could elaborate. The benefit of my experience is that indeed, if the matter is not terribly complex and the matter can be determined by just submitting perhaps just a brief to the arbitrator, then that really reduces time and energy and cost for the client, but it really depends on what the facts are. What do you say about that, Bruce?
Yeah, no, that's right. Ultimately, it's the parties that can design the arbitration process. So what I mean by that is the court process is set out more or less by legislation. It has to go in a certain process, and you have certain ways of introducing evidence to the judge and cross-examination and transcripts and so forth. In an arbitration, if you don't want to, you don't have to go through all that process. You can make it as simple and as cheap as you like, from simply just the two parties to the dispute providing me with their written statements, and then say, Mr. Arbitrator, please make a decision on the papers. And that's at one end of the scale. On the other end of the scale, you can make it look as if it was no different from the court process itself. Obviously, that would be a lot more expensive. Then there's all different ranges in between. You can have no requirements for cross-examination. You can ask for the strict rules of evidence to apply or not. You can, and what we've learned through the last 18 or so months is that arbitration is very much open to the flexibility of the online world in terms of video linking parties in and dealing with the evidence in a piecemeal way. So maybe on a number of afternoons rather than having to have it all in one hit on a day. So in that way, it's a lot more flexible. And the parties feel like they've participated in setting up the process rather than the judge saying, this is how it has to happen and you must comply.
We all know that separating parties aren't always in agreement on many matters. What if they disagree with how the arbitration should run?
Well, ultimately, the arbitration is under the umbrella of the family court system. So if it is a matter that has come through initially the court process, and we call that a referral pursuant to section 13 capital E of the Family Law Act, so a 13E arbitration, the court ultimately retains jurisdiction, retains the oversight. So if there's some problem that is beyond the jurisdiction, well, the purview of the arbitrator to make a decision upon, the parties can apply back to the judge for an order or a direction in the arbitration if they can't agree.
So Leisa, would there ever be a situation where you wouldn't recommend a client go through arbitration?
Okay, so that's a hard one because I think everything can be arbitrated. At the moment, they won't allow you to arbitrate children's matters because they say that, you know, the evidence is too restrictive. You've got to see the parties. The judges are the only ones who can really arbitrate those matters. I disagree with that. I think that arbitrators, good skilled arbitrators who have background in children's matters can arbitrate. I think we need to open that floodgate because there are so many, most of the matters that are backed up in the family court system are children's matters. So in answer to your question, no, I don't think that there is a restricted process in relation to the arbitration. I think that it's, if you have a skilled arbitrator who's got a very sound background in many matters, property matters, children's matters, more than capable of being able to make a decision in that arbitration mold. You know, arbitrators will be assisted, of course, by experts regarding family report writers, psychiatrists, so that they have the body of evidence to rely upon. They're just bringing their knowledge and expertise to it. So I don't think it's I don't think that it should be restricted to just property matters. Bruce, what do you say about that? Do you think that's right?
So firstly, I'll answer the question in terms of what is currently not appropriate for arbitration, and then maybe pick up on what you've just discussed there, Leisa, because I know that has been the subject of recent reporting by the Australian Law Review Commission. In terms of the existing jurisdiction, is really just restricted to financial matters, and even within that set, there's subsets of matters that can only be arbitrated and some that remain strictly the sole jurisdiction of a judge. For the purposes of today, most parties' financial disputes will be able to be determined by an arbitrator. There are some financial matters which might not be appropriate. They are usually where there's some serious issues or findings of fact concerning criminality or domestic violence. So where there's issues of tax fraud or fraud against the public revenue or fraud on another party or a third party, those are usually the matters that should probably be run through a judge and not an arbitrator. Because arbitrations are confidential, so it would be against public policy to make a decision and keep secret, essentially, from the revenue authorities where there's been a fraud committed against them.
Sorry, so just to break that down, Letitia, what Bruce is saying is that if a party defrauds Centrelink or the ATO and tells lies in relation to what they're telling the taxman or Centrelink, the judges now have the power, and they have had, I should say, for some time, to refer the matter off to an authority for prosecution, for investigation and prosecution. So that's a really relevant point that Bruce has made, that arbitrators don't have that power. But certainly judges do. And I think but I think, Bruce, would you think that would be the only, the only exemption?
And there is a school of thought that where there's what we call a canon argument, and Leisa will explain what a canon argument is that probably needs to go through a judge, because the judge is going to be required to make findings about whether or not there has been family violence through the relationship. But again, the parties might think that proportionally that part of the claim is not significant enough to merit the costs or the waste, or not the wasting, but the delay in time of waiting for a judge's decision, and might still run that argument through an arbitrator. And I know that many skilled arbitrators do determine canon type arguments. The final one would be where a party is disadvantaged. So if there's a self-represented disadvantaged litigant, it would not be, in my view, best practice to go through arbitration.
So just going back to that canon argument, Letitia, that's where the court's entitled to take into account significant domestic violence that's been in a relationship. And there's a high burden of proof on that, by the way, and whether or not that's impacted on the financial contributions the parties have made to the relationship. And they can make an order or a weighting, depending on what the impact of that domestic violence has been. So that's a fairly serious argument to run. They're very difficult arguments to run, but I certainly agree with Bruce that that may need some judicial intervention.
So based on that, is there the risk, I guess, of getting through partly through an arbitration to find out that actually, yes, the matter should be referred to a court because you weren't aware of any of these instances?
Not likely. The way, at least I run my arbitrations, and I think most arbitrators run their arbitration, is the first step is I convene what I call a timetabling conference. And by that conference, I will have received the material from the parties or their solicitors and gathered an understanding of what the dispute's really about. From there, with the parties' assistance, designed the process. So it's not something that you would be surprised about. I'm not saying it wouldn't ever happen. Of course, it could happen, but therein lies the flexibility of arbitration. If the material came in and all of a sudden a party had turned left in terms of how they ran their argument, well, then there's the capacity of adjourning for a short period to enable the other party to essentially put on evidence to respond to that. Whereas if that happened in court, you'd have an adjournment application and the matter would disappear for another 6 months to 12 months before it came back before the court. You usually work out quite early what the issues are in dispute, so you'd rarely be surprised by that kind of thing.
Sure. So, Leisa, if someone is interested in going down the route of arbitration, what is the process from your standpoint? How do you prepare a client, and what are the actual filing proceedings?
So the first thing you've got to do is actually get consent from the other side to actually agree to arbitrate, because it's really a consensual process. So if you can get an agreement from the other side about that, then it's a fairly flexible process, as Bruce has been pointing out. So you pick your arbitrator. Your arbitrator will issue their rules in relation to how much they arbitrate, and that the other side, you agree to follow those rules. They may be a bit malleable about what evidence has got to be put forward. There may be a lot of facts that are agreed upon that can just be set aside, and you may have the opportunity of just running what we call a discrete arbitration and picking points that are the salient points that really turn the case and that you need a decision on, which will then allow the parties to maybe box on and reach a final agreement. So there are many avenues or uses of arbitration, rather than just saying, okay, well, I want my arbitrator to issue an award. So an arbitrator may, during the course of the process, not give an indication. That's not what they're allowed to do, but what it will allow you to do is you'll see the evidence unfold. As you see the evidence unfold, if that's the process you're undergoing, then you kind of get the idea of where the matter may end up, and you may end up with an agreement anyway without even getting to an award. Bruce, has that happened in your experience?
Yes. On a couple of occasions, we've started off the arbitration process with timetabling, and exactly that. We've been trying to work out, well, what is already agreed between the parties. So, for example, often the starting point is a balance sheet to try and reach agreement about what we're trying to divide up. And in the two cases that I had, we started that process and determined, well, once we get some valuations back in, let's come back and reconvene this timetabling conference. And from that process, the parties realised that they weren't actually that far apart, and we spent the rest of the day. I facilitated a mediation, more or less, and it resolved. So you didn't need to go to a hearing. You've got to remember, with arbitrations, it's a form of dispute resolution. So it's ultimately, however the parties agree for the dispute to be determined, is how it will happen. So if they want to start off with an arbitration and then go into a mediation and then come back to an arbitration, if that's the process they agree upon, well, that's what we can facilitate.
Well, that's someone. Sorry, Bruce. Continue.
No,
That was it.
Well, that's sort of, and to flow on from Leisa, I think that's, good lawyers in Leisa's position. They explain to clients, well, you really have to exhaust all forms of dispute resolution before you go to court, and court should now be seen as last resort. And arbitration is just another form of dispute resolution before you go to court.
So I guess that leads me to the question, we all know how court costs can blow out, and one of the scariest things about getting divorced, which can deter people from getting a divorce, is the cost associated with it. Is there a way of setting a budget and setting a time frame? Is that possible?
That's the whole purpose of the timetabling conference, is to set out a timetable of steps that need to be done and when the parties can expect to have their decision or their award. And I say, well, I think this is what it's going to cost me to do that for you. And if they agree to that, fine. If they don't, well, maybe they need to find another arbitrator. It depends on how the arbitration has landed on my lap. Sometimes the order has already been made by consent pursuant to Section 13E that I am the arbitrator, and I've not
got no choice
yet.
So essentially, it's a fixed price settlement, a divorce.
More or less. I've learnt over the years to factor in for variables such as applications that parties tend to want to make during the course of the arbitration, or voluminous documentation that I suddenly have to read.
And on the back end of that, Letitia, the beauty about the timetable is that as a lawyer, I can then give a really, more or less accurate assessment on what it's going to cost a client to go through the arbitration process, for the documentation that's required, the response material, those sorts of things. So you can give a really accurate outcome about the cost, so the client knows what they're getting themselves into.
And like all things, this can be a very emotional process. So I'm assuming, things can take longer if there is that the parties are emotional or they're trying to incite a fight, either side or both sides. Is there a process of appeal? Because like a family court, is it final?
Oh, maybe I'll get this one. So it's not called an appeal, it's called a review, but most people would understand it to be an appeal. But it strictly is just a review, and it's a review on a question of law. So in some respects, that's a little bit narrower than how you can appeal from the decision of a judge in the family court system. But that's the point. You're trying to reduce the costs, you're trying to create certainty. So you're trying to limit, and the government has limited the way in which you can seek to unravel an arbitrator's decision. We have to ultimately give our decision in accordance with the law. We can't just make it up or exercise what they call palm tree justice. We must apply the Family Law Act and the settled legal principles. We must afford everybody procedural fairness and natural justice. And to do anything otherwise, a family court will review the decision and set it aside, and the parties will have to go back and have another arbitration, perhaps.
Leisa, how would you prepare a client for arbitration?
Well, that would depend on how we decide to conduct the arbitration. So if we're doing the arbitration on the papers, I would extract evidence from my client, put together material, affidavit material. Oh, indeed, actually, there's a question, Bruce. For the purposes of arbitration, does the evidence always have to be in a solemn form?
No. If the parties agree just to simply file written statements that they sign, then that's something we can agree upon. You can, obviously, the parties don't need to have the strict rules of evidence apply. So the rules of hearsay, for instance, where you simply just attach documents from other parties, like a report from your doctor or the usual red book valuation that you print off the internet, that can be accepted by me as evidence where the parties agree that that's the form in which I can receive evidence. And obviously that saves parties a lot of money if they can avoid having to pay for expert fees. And of course it's, you have to match the cost with the importance of the outcome of that.
Yeah, spot on. And actually picking up on what Bruce has just said, Letitia, you bespoke the arbitration to what you're actually fighting over. So, you know, if it's a large sum of money, then you'd certainly need some more evidence, and you need to be, you know, putting a bit more time and energy into what you're collating to make sure the case is really it represents accurately the pool that you're arguing over. If indeed it's a modest pool, and by the way, this is really where arbitration should be at the forefront, because I have seen decisions come through in recent years where the pool of assets has been no more than 200 to 300,000, and I have just been gobsmacked that people are going to trial fighting over pools of assets of $200,000 to $300,000 when we know it costs up to $50,000 to $60,000 to run a trial. It's just incredulous.
That's where that the court's P 500 list has stepped up to the plate, to use the vernacular, in that, Letitia, where the property pool is identified to be less than 500,000, the court's registrars steer the parties almost immediately into an alternative dispute resolution mode, firstly with a conciliation conference through the court, and then if they can't resolve it, then the registrars are strongly recommending the parties pursue arbitration. For that very reason that Leisa suggests, is that those are the matters that can be determined quite efficiently and economically by an arbitrator, because the dispute's nearly always about what we call weight, what weight to apply to particular facts or matters, as opposed to having to sift through the evidence and listen to the client or the evidence and make credibility findings. The small pools are usually not those.
But we also know that there are clients who just want to be in a fight, and, you know, whether it be through arbitration or a court, they're going to keep fighting because it's, you know, who knows why, but they just do. and could potentially spend just as much in those circles. I'm just speculating anyway.
No,
but
you're pretty accurate. There are clients out there who just, it's very difficult to manage that type of expectation.
I always feel that nobody ever really wants to genuinely be in the court system. Most people, most litigants are what I call are reluctant litigants. They would rather be anywhere else than in court. Of course, you get the odd few that we know that would, such as certain former senators, they would just love litigating apparently. But the most family law litigants, I don't think they want to be there. They just don't know how to resolve it in another way other than through court.
Well, Bruce, do you find they're not ready to resolve it? Like we've been through matters where we know what the answer is. The answer is really clear, but the client has to be ready to accept it. And that's part of the problem going through the process. The court, with all due respect, and I know the family court and the federal circuit court, they're all very hard workers, but they're just overburdened. They've got too much going on. And, this idea of arbitration, people should be embracing it because it's the way of the future, I believe anyway. I think the courts should be more treating the arbitration process as a more symbiotic relationship. What do you say about that, Bruce?
I agree. I think from the commencement of the new court and with the introduction of the new combined rules, any solicitor or barrister for that matter that thinks that arbitration is not the way will be in for a rude shock. There will be a even heavier emphasis upon parties in financial matters being steered to and asked to establish that they have exhausted all attempts in dispute resolution, which includes arbitration, before they'll come anywhere near being before a judge for a final determination. And to reinforce that is there's very strong messages from all stakeholders that arbitration should be, the jurisdiction of arbitration should be expanded to include determining parenting matters. And it is for what you just said, Lisa. Our family court system and the judges are working flat out, but they are still overburdened with volumes of matters, most of which are parenting matters. And most of those parenting matters involve serious allegations of some form of harm or domestic violence, which take up a lot of the judge's time. There's a lot of parenting matters that don't meet those problems or don't have those kind of problems, which can be determined by an arbitrator. Should be.
And look, let's be honest, any form of proceeding and, separation, divorce, it's hard on the families and the individuals and the children. So the quicker we can find a resolution, whether or not both parties or any of the parties are happy, at least it's a resolution and they can start rebuilding their lives from that point on and create a new normal. You said it's quicker than, waiting times currently are up to 24 months. How quickly, when we're talking a comparison, how quickly could people get into an arbitrator?
Tomorrow, effectively. If you're ready to go and you want to meet with me, my diary is available as soon as the parties are available. And we're in this new world now where we've just got so much more flexibility with getting the cats herded, so to speak, and having an online video session where everybody's effectively in the same virtual room. It's then up to the parties and their solicitors how quickly they can get everything ready for me. And then I try to provide a decision within 14 days of the final bit of evidence being received.
So, I mean, look, for me, what I'm hearing is it's less costly, quicker, And it's less stress, because one of the things that I think is really daunting that people don't realize if they've never been into a court, going into a court with a judge and all those formalities and the bowing and all of that sort of stuff, it can be really overwhelming. And if you're already in an emotional state, that's not going to be adding to, that's going to add to the stress. So is that one of the things as well, Leisa, that you recommend with clients that they keep in mind?
Oh, absolutely. I mean, it's so much more user-friendly, and, you know, you're right, court is very intimidating, and no one in their right mind should want to actually walk into a courtroom. So that's why mediation and arbitration are just gems for family lawyers.
Do people have to bow at you, Bruce?
No. No.
So the formality, sorry.
I just get called Mr. Thiele or arbitrator. So that's all. There's no formal title bestowed upon me.
That was kind of a joke, but I could imagine.
And indeed, it's actually in serious. And you probably, if you ask some of the barristers or solicitors that do or have done arbitrations before me, they probably found it a little bit more comfortable, because you're not in a court. We're usually in a large conference room near to where everybody is. And everyone can stay seated. There's no requirement to stand when you're cross-examining or addressing me. So there's a layer of comfort there. I know some arbitrators do the reverse and make it look almost like a court, but I don't think that's needed in my personal view.
It sounds
wrong. It's just my personal view.
For you, yeah. It sounds more personal and less of a performance.
Yeah, I guess so.
So is there anything else that you'd like to add about arbitration, Leisa, in terms of whether or not you're a client or a family lawyer considering going down this path?
Look, I think we all need to have a bit of a reset in relation to arbitration. At the moment, I'm talking to other practitioners about arbitration, but I, for some reason or another, I'm getting a bit of pushback. I just think we need to get more people understanding that it's such an excellent way of moving things along. If we could get practitioners having a bit of a reset and a rethink about it, I think we'll find that it'll take off. I don't know, Bruce, are you finding that, you know, it's a bit of a slow burn?
No. This year I've been quite busy with arbitrations, and to the extent hung up one phone call yesterday just to answer another one. Both those phone calls were about trying to schedule arbitrations, and I'm not certain what has produced the
rush,
the energy behind all of that, other than to suspect that it all comes back to the time issue. There is a real timeliness. I think a lot of people don't want to miss this economic bubble in terms of selling real estate. They want to get that sorted out now while the wave of the at least local real estate market is quite high, where it could be something completely different next year. We just don't know. So it's the certainty about today and getting things done quite quickly. There's also as I said, the P 500 and our registry with our registry case judge, Judge Middleton, very much endorsing arbitrations at every stage, and our Chief Justice, Justice Ostegren, endorsing arbitration at every stage. So that it has become a real surge. Whereas when I started doing this in 2015, I was spending a lot of time marketing arbitration. I'm not finding I have to do that as much anymore.
Sorry, Bruce.
And I think also a lot of senior solicitors and barristers are now enrolling to undertake the arbitrator's course, maybe not necessarily because they want to become arbitrators themselves, please don't. But I think it's so that they get a better understanding, and when they do, it's almost like the
penny will drop.
The pennies drop or the shades.
Yeah. And that's what I'm feeling. I'm feeling that when I talk to practitioners about arbitration, you know, I'm being, you know, we have to have a full-length conversation about what's it going to look like, you know, what will it mean, how do we go through the process, you know. So it's for me, it's a bit of a sell factor at the moment with practitioners.
But what's the resistance? Sorry, can I just ask, what's the resistance though for those who?
I think it's ignorance.
Yeah,
I call them
I'd agree.
Non-ambulatory pigs. You're just not going to be able to shift them because they don't want to be shifted. And sadly, it's either the legal professional behind it just chooses to remain ignorant about the benefits or what arbitration is and the benefits, or the client knows that there's no benefit to them in advancing the matter earlier. There are some clients who will say, well, it's better for me in my case or for me just personally that I just drag this out as long as possible. And that's the one limitation with arbitration. A court can't compel a party to arbitration. It has to be by the unequivocal consent of both parties. So that's the traction, I think. But with the legal professionals, either because they're just getting a bit more information or they've had a few kicks to the ribs by a registrar or a judge down in our family court system, they're becoming fewer and fewer.
Well, I think with everything going on in the world at the moment, the amount, if we can reduce the fight and the angst and the heartache and all of that emotional stuff, I think anything that anybody can do, professional or personal, is a good thing. Thank you for joining us, Leisa and Bruce. And I know, having the level of experience that you do, you are making a positive impact, and that the best interests of your clients are at heart, and getting people through these kinds of yucky matters quickly and with the least amount of impact to their families and future is at the forefront. So thank you very much for everything that you do and joining me.
Thanks, Letitia.